Hello everyone. In this presentation, an attempt is made to explain as to how the Supreme Court used Article 21 as a tool for improvement of the environment for the well-being of the people, leading to the evolution of environmental jurisprudence in India. Whenever the ecological balance is disturbed and the natural conditions of rivers, forests, air and water, which are the gifts of nature, are tampered with, the quality of life of the people would be affected. Right to life includes right to quality life, and this in turn would mean that a person has a right to the enjoyment of pollution-free air and water to enjoy life fully. Improving public health is a directive principle under Article 47, and protecting and improving environment and safeguarding forests and wildlife of the country are directives under Article 48A. A fundamental duty is imposed on all the citizens under Article 51AG to protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and show compassion for living creatures. A number of statutes have been enacted and administrative machinery has been put in place to deal with environmental pollution. The legislature enacted the Water Prevention and Control of Pollution Act 1974 and the Air Prevention and Control of Pollution Act 1981. It also enacted the Water Prevention and Control of Pollution Cess Act 1977. Under these acts, rules have been framed to give effect to the provisions thereof. On account of depletion of the forest cover, the Forest Conservation Act 1980 was enacted to regulate the diversion of forest area for non-forest purposes. Thereafter, the Environment Protection Act 1986 was enacted to provide for the protection and improvement of the environment and for matters connected therewith. But due to administration's apathy, nothing significant was done to control environmental degradation. The activist approach of the Supreme Court resulted in taking cognizance of various environmental problems in a number of cases and giving necessary directions to the central and state governments and to the concerned authorities for prevention of pollution, protection of environment, and for conservation of forests and wildlife. The Supreme Court applied doctrines like public trust doctrine, polluter-pays principle, precautionary principle, and the doctrine of sustainable development along with Articles 47, 48A, and 51AG of the Constitution and certain international conventions and treaties to protect the rapidly deteriorating quality of air and water. The public trust doctrine primarily rests on the principle that certain resources like air, sea, waters, and the forests have such a great importance to the people as a whole that it would be wholly unjustified to make them a subject of private ownership. The said resources being a gift of nature, they should be made freely available to everyone, irrespective of the status in life. The doctrine directs the government to protect the resources for the enjoyment of the general public rather than to permit their use for private ownership or commercial purposes. This doctrine was used in Karnataka Industrial Areas Development Board versus C. Kenchappa. The polluter-pays principle demands that the financial costs of preventing or remedying damage caused by pollution should lie with the undertakings which cause the pollution or which produce the goods which cause the pollution. Under the principle, it is not the role of government to meet the costs involved in either prevention of such damage or in carrying out remedial action, because the effect of this would be to shift the financial burden of the pollution incident to the taxpayer. This principle was applied in Indian Council for Enviro-Legal Action versus Union of India and others. The polluter-pays principle was promoted by the Organization for Economic Cooperation and Development during the 1970s, when there was great public interest in environmental issues. During this time, there were demands on government and other institutions to introduce policies and mechanisms for the protection of environment and the public from the threats posed by pollution in a modern industrialized society. According to the precautionary principle, the state government and the state authorities must anticipate, prevent, and attack the causes of environmental degradation. The onus of proof is on the actor or the developer to show that his action is environmentally benign in real and practical terms. In the absence of adequate information, the authorities must lean in favor of environmental protection by refusing rather than permitting activities likely to be detrimental. This principle was used in issuing directions in MC Mehta versus Union of India. Sustainable development means a development which can be sustained by nature with or without mitigation. In other words, it is to maintain delicate balance between industrialization and ecology. While development of industry is essential for the growth of economy, at the same time the environment and the ecosystem are required to be protected. The pollution created as a consequence of development must not exceed the carrying capacity of the ecosystem. The courts in various judgments have developed the basic and essential features of sustainable development. In order to protect sustainable development, it is necessary to implement and enforce some of its main components and ingredients such as precautionary principle, polluter-pays principle, and public trust doctrine. In addition, when rights were violated by disturbing the environment, the court awarded damages for compensating the victims of disturbance as well as for restoring the ecological balance. Indifferent attitude adopted by several state governments is one of the major reasons for widespread environmental pollution and ecological imbalances in India. This attitude compelled public spirited individuals and civil societies to challenge the various actions and inactions on the part of the government and the statutory authorities responsible for preserving and protecting the environment. Now, let us examine some of the important decisions of the Supreme Court relating to the right to clean environment. Rural Litigation and Entitlement Kendra versus State of Uttar Pradesh was a case pertaining to mining of limestone quarries in Dehradun, Mussoorie area. It was the first case of its kind in the country involving issues relating to environment and ecological balance. The questions that arose for consideration were of grave concern and of significance to the people residing in Mussoorie Hill Range, forming part of the Himalayas, and also in their implications to the welfare of the generality of people living in the country. It brought into sharp focus the conflict between development and conservation and served to emphasize the need for reconciling the two in the larger interest of the country. In this case, directions were issued regulating the mining activities in limestone quarries operating in Dehradun. A number of petitions were filed by environmental activist Mr. M.C. Mehta, bringing to the notice of the court various aspects of environmental pollution. The Supreme Court issued directions which helped in tackling serious environmental issues, which include the directions to tanneries in Kanpur and Calcutta to stop polluting Ganga River in MC Mehta versus Union of India, directions for closure of certain hazardous industries, direction for removal of hazardous and obnoxious industries from the residential area, directions issued for protecting ancient monuments, including the Taj Trapezium, and directions to control vehicular pollution in Delhi and other cities. In MC Mehta versus Union of India 1988, steps have been taken by the court to ensure spreading of awareness about the conservation of environment among people including children. In MC Mehta versus Union of India 1998, the court appointed expert committees wherever necessary and monitored the implementation of its directions for years to check environmental degradation. The Supreme Court also issued directions for stopping and regulating mining operations in MC Mehta versus Union of India 2004. In Buffalo Traders Welfare Association versus Maneka Gandhi, directions for closure of slaughterhouses and its relocation were issued, and the directions for setting up effluent treatment plants to the industries were issued in Paryavaran Suraksha Samiti versus Union of India. In Indian Council for Enviro-Legal Action versus Union of India, a writ petition was filed by an environmentalist organization bringing to light the woes of people living in the vicinity of chemical industrial plants in India, highlighting the disregard and contempt for law and lawful authorities on the part of some emerging entrepreneurs who take advantage of the country's need for industrialization and export earnings. The effluents from the industries resulted in environmental pollution, especially air and water pollution. The Supreme Court took note of the serious health hazards that result from such pollution and directed central government to consider and examine about establishment of environment courts, strengthening the environment protection machinery both at center and in the states, and providing them more teeth, personal accountability of the industrial units for their lapses and negligence, and formation of environmental audit. In Indian Council for Enviro Legal Action versus Union of India 2007, the Supreme Court, by applying polluter-pays principle, ordered compensation to be paid for loss suffered by farmers due to pollution of subsoil surface water resulting from discharge of effluents by pesticide industries situated within that stream from the contribution of industrialists. In Indian Council for Enviro Legal Action versus Union of India 2011, the Supreme Court held that the right under Article 21 included maintenance of ecological balance, conservation of natural resources, and compensation for loss suffered by citizenry due to effluent, sewage, industrial and hazardous material and waste. When the polluter expresses inability to deposit estimated demand for remedial measures, the court directed the Ministry of Environment and Forest to take alternative steps, that is, attachment and sale as per directions of the court. In yet another set of petitions filed by yet another social action group called Research Foundation for Science, the Supreme Court discussed the ecological imbalance that would be caused by dumping of hazardous waste and its impact on flora, fauna, environment, and the well-being of animals and human beings. The court held that for setting up of alumina refinery project which involved mining of bauxite deposits in area concerned including forest land, sustainable development approach has to be adopted. Adherence to the principles of sustainable development is now a constitutional requirement. When issues relating to deforestation, diversion of forest land to development activities, and illegal mining were brought before the court in T.N. Godavarman versus Union of India, certain directions were issued to states banning felling of trees. It was further held that natural resources are assets of nation and there is an obligation to conserve and not waste them. Any threat to ecology leads to violation of right to enjoy healthy life guaranteed under Article 21. Conservation includes preservation, maintenance, sustainable utilization, restoration, and enhancement of the natural environment. Directions were also issued for creation and use of compensatory afforestation fund for compensatory afforestation, where permission is granted for diverting forest area for non-forest purpose in T.N. Godavarman versus Union of India 2006. Emphasizing the need to establish viable institutions comprising professionally competent persons and strengthening such institutions, the court in Teji Tega Tara versus Rajendra Singh Bhandari issued directions to the executive in all the states to appoint suitable experts and professionals to the pollution control boards. The Supreme Court thus took every available opportunity that came its way to prevent undue exploitation of natural resources like water, forests, mines, and minerals, to control air and water pollution, and to preserve ancient monuments adversely affected by air and water pollution. The aspects involved in these cases were highly technical in nature, but the court took the help of special committees appointed by it and issued directions in the nature of mandamus and monitored the implementation of these directions on a regular basis. Thus, the last 5 presentations have been dedicated to highlight the huge contribution made by the Supreme Court at the instance of public-spirited citizens and civil society in expanding the scope of Article 21 in such a way as to cover every aspect of human life that goes to make it meaningful and to ensure that the goals set in the preamble of the Constitution, that is, liberty, equality, and justice to all, become a reality. Thank you.